Dear all, good morning, good afternoon, good evening, depending on where you are. We start our second day of the arbitration conference of the Ukrainian Arbitration Association, and I'm delighted to introduce the keynote speaker of our conference, Alexis Mourre. Alexis Mourre is president of the ICC International Court of Arbitration, the most preferred arbitral institution in the world according to the recently published global survey by Queen Mary University London. He has served as parties counsel, arbitrator, or expert in more than 260 international arbitrations, both ad hoc and before many arbitral institutions. He established his own arbitration practice in May 2015 after having founded Castaldi Mourre and Partners in 1996, a French firm specializing in arbitration and dispute resolution. He is also the author of numerous books and publications in the field of international business law, private international law, and arbitration law. He is founder and former editor-in-chief of Le Cahiers de l'Arbitrage, the Paris Journal of International Arbitration, a leading French publication in the field of arbitration. Since 1st July 2015, Alexis Mourre has been the president of the ICC International Court of Arbitration. Before that, he served 2 terms as vice president of the court. Among his past appointments, I could also mention vice president of the ICC Institute of Business Law, co-chair of the IB Arbitration Committee, LCA court member, council member of the Milan International Chamber of Arbitration. Alexis is also a member of a large number of scientific and professional institutions dedicated to arbitration and private international law. He is the founder and former president of Paris Place d'Arbitrage, Paris, the home of international arbitration. We are very happy to welcome Alexis today at our conference. Alexis, the screen is yours.
Thank you very much, Olena. I hope you can hear me well. And I'd like to thank you, Olena, and to thank the Ukrainian Arbitration Association for inviting me to this event today. And this speech comes at a particular time for me because, as you may know, I will leave my position as president of the ICC Court of Arbitration next month. And these 12 years at the court, 6 as vice president and 6 as president, have been as challenging as they have been rewarding. I've been deeply honored to chair the court during these years. These have been years of reform, of transformation, of changes for the ICC, for the court. These have been years of significant growth for the court, and also years during which the court has been faced to a fast evolving arbitration marketplace, to a very, very fast evolving arbitration environment, to a more diverse, more competitive, and more demanding arbitration marketplace. These have been years of intense activity for the court, with 2 sets of amendments to the rules, with the opening of 3 new case management offices in Sao Paulo, Singapore, and now Abu Dhabi, and with the elaboration of a deeply transformed and renewed practice note. And as this journey comes to an end, it is also time for some general reflections on the past and also for thinking on the future. The arbitration world has been characterized in the past 15 years by a number of important evolutions, and I will also mention the 3 which I see as the most significant ones. The first is the consolidation of the central role of arbitral institutions. That trend has begun in the last decades of the last century, but the predominance of institutional arbitration as opposed to purely ad hoc is now fully confirmed. And that means that the net of arbitral institutions has now become the structure and the backbone of arbitration as a global system of justice. That also means that institutions concentrate much more powers than they historically did. And that means that institutions are a tool for any future significant reform of the law and practice of arbitration. This should not surprise anyone. We should not forget that in 1958, the ICC was at the initiative of the process which led to the adoption of the New York Convention. Should be one of significant diversification, both geographically and from a generational and gender perspective. Geographically, arbitration is no longer the Western industry that it used to be 20 years ago. Look at the recent Queen Mary White and Case survey that Olena has mentioned. You will see that more than half of the respondents originate from Asia, and that shows how committed the Asian community is in arbitration. You see around the world new institutions being created almost every year or every month. You see the rise of regional institutions. You see the development of new arbitration seats. You see new arbitration committees developing around the world. You see a much more environment. From a generational point of view, arbitration is no longer an industry which is for old, I would say, very senior practitioners. You see now, and we see at the court, a new generation of arbitrators in their 30s and their 40s producing excellent awards, and there is, without any doubt, a very important process of renewal. From a gender perspective, some of you perhaps may remember that 15 or 20 years ago there was only one woman in the court, and that was our friend Antonia Zdemolica. We now have gender parity. We have 20% of our arbitrators confirmed. We have a population of 1,600 arbitrators confirmed or appointed every year, and the proportion of women is rising every year. And the consequence is that in a much more diverse environment, there is more need for consensus on transnational rules. There is increased need for the development of soft law rules. There is an increased need for the establishment of a level playing field, because arbitration is no longer a community of limited practitioners who know the non-written rules of the game. It is now an open and diversified market, and in an open market there is need for written rules, there is need for legal certainty, and there is need for equal access of all to the rules and to the practice of arbitration. And the third trend, which is noteworthy, is of course the intensified public scrutiny to which arbitration is submitted, not only in the field of investment arbitration, of course, but also in the field of international commercial arbitration, where significant public interest is often at stake. Let us not forget that in 2020, about 20% of our new filings at the ICC involved a state or a state entity, and this goes with a growing expectation for more transparency, for more accountability on the part of arbitrators and institutions, and for more efficiency, of course. And in this fast evolving landscape, I would like to suggest that three questions deserve the urgent attention of arbitral institutions and of the international arbitration community. These questions are potential evolutions for the future, they are field for reform, and they are conditions, I think, for the continued legitimacy and development of arbitration as the normal way of resolving international disputes. The first of these three questions on which I would like to say a word today is the question of conflict disclosures. Arbitration is an industry that is fundamentally based on trust. It is exactly like the banking industry. Banks rely on the trust that depositors have that they will be able to recover their money. Arbitration rests on the trust of the parties that conflicts are disclosed in a forthcoming and transparent way. And this is particularly important in an industry where international arbitrators necessarily entertain multiple relationships with parties, counsel, and other arbitrators. if conflict disclosures are not made in a forthcoming and transparent way, then the integrity of the entire system goes away. Disclosures are the necessary condition for the parties to be able to exercise what is a fundamental right. It is the right to object to the nomination or the appointment of an arbitrator, or the right to challenge the continuous participation of an arbitrator in an arbitral tribunal. If a disclosure is not made, the parties are deprived from the information that they need to exercise that right, and therefore the question becomes a question of the validity of the award, with, of course, very, very significant and serious consequences in case of nullity. And I would like to draw your attention to a significant development, which is the recent decision made by the European Court on Human Rights last week, I think, in the case Becchetti versus Italy, where the European Court of Human Rights has decided that the lack of disclosure by an arbitrator, and in that case, it was the participation of the arbitrator in the board as vice president of the board, the mother company of the respondent party to the arbitration, that had the effect of depriving the other party from the opportunity of challenging that arbitrator, and that has resulted, says the European Court of Human Rights, in a violation of Article 6.1 of the European Convention of Human Rights. That's very significant. That's the first time that the European Court of Human Rights addresses that particular question, and that confirms that the transparency of conflict disclosures is a fundamental condition for arbitration proceedings to comply with the requirements of due process. If disclosures are not made, then the entire process becomes questionable. Now, the problem is that we still lack an internationally standard for disclosures. The IBA adopts a subjective standard, so does the ICC, which is to say that disclosures need to be made in the eyes, according to a standard in the eyes of the parties. Arbitrators need to disclose every circumstance that is likely to question or to put a doubt on their independence or impartiality in the eyes of the parties. Whereas the model law adopts what some characterize as an objective standard, which is in the eyes of a fair-minded and informed observer. Those of you who have read the recent Halliburton decision of the United Kingdom Supreme Court will have seen that the court addresses that question by confirming that the standard for disclosure in the United Kingdom is an objective one in the eyes of a fair-minded and informed observer. And it's interesting to see that the decision describes what is that fair-minded and informed observer. Who knows the case, someone who is able to exercise fair and independent judgment, and therefore is able to decide objectively of what disclosures deserve to be made and what disclosures do not deserve to be made. Now, this, for me, is very problematic. Why is it problematic? Does it make a difference that the IBA adopts a subjective standards for disclosure as opposed to an objective one for the model law? Perhaps in the practice of institutions, it doesn't, but conceptually, it makes a lot of difference. It makes a lot of difference because the objective standard in the eyes of a fair-minded and informed observer implies conceptually that the arbitrator will exercise some level of judgment as to whether circumstances should be disclosed, not only because they are susceptible to raise doubts in the eyes of the parties, but because reasonably in the eyes of a fair-minded observer, they are so. The problem is to allow the arbitrator to cast a judgment on his or her own neutrality or independence. And that's why I believe that the subjective standard that is adopted by the ICC is preferable. It's preferable because it implies a broader standard. It implies broader disclosures. It implies that the arbitrator should not put himself or herself in the foot of the judge. He or she should not be the judge of his or her own conflicts. Now, is the subjective standard as approved by the ICC or the IBA ideal? Probably not. There still is room for moral hazard. You still have the possibility, exactly as under the objective standard, that an arbitrator would not disclose, either because consciously decides not to do so, which is, of course, very bad, but also because of unconscious biases. You can have a situation whereby a young arbitrator who's very much willing to take a case will, at the end of the day, consider that the circumstance that would risk him losing the case should not be disclosed. You have experienced arbitrators who believe that they know better than anyone else, and therefore they know that the circumstance is not relevant, or they believe that the circumstance is not relevant. Whereas that determination should not be made by the arbitrator; it should be made by the institution or by the judge. Now, there are encouraging signs on this front. I would like to draw your attention to what UNCITRAL and ICSID are doing with the project for a code of ethics for adjudicators. And it's interesting that in Article 10 of that draft code of ethics, ICSID and UNCITRAL adopt a standard which is a subjective one in the eyes of the parties, but they complement it with a list of objective circumstances that arbitrators have to disclose. So it is a mix of the objective IBA ICC standard with a purely objective standard, which is in essence the obligation to reveal some circumstances which are listed. And the ICDR has a formal disclosure which is close to that, and I think that is the way for the future. So the first thing I wanted to say is that moving ahead in the future, the arbitration community will need to address that question. There will be the need, I think, for a globally accepted standard providing from full transparency in conflict disclosures. And I think that what ICSID and UNCITRAL are doing now is the way to go, not only for investment arbitration, because the draft code of ethics is for investment arbitrations, but also for commercial arbitration. Now, the second evolution that I would like to see in the future is on the front of transparency, i.e. the endorsement by institutions and by the arbitral community of a principle of full transparency, not only in ISDS, in investment arbitration, but also in international commercial arbitration. Arbitration, and in particular commercial arbitration, is still embedded in a culture of secrecy, which, in my view, which checks its efficiency and which threatens its legitimacy. There should be now a transparency revolution in arbitration, and this has several aspects. The first is transparency in institutional rulemaking. Decisions made by institutions on challenges, on prima facie jurisdictional determinations, on consolidations, as well as other decisions which are such as to significantly affect the rights of the parties. Reasons should be provided. Some institutions do that, the LCIA, the ICC, and others, except, of course, that should become a general practice. Second, transparency of the institutional governance of institutions, the composition and selection of board members, of court members, who is sitting in these bodies, who is sitting in other decision-making bodies of the institution, the adoption of governance rules such as to ensure the full independence of the arbitral institution from their chambers. All this will become a fundamental condition of the integrity of the system, and there will be the need, again, for internationally accepted rules across the board that all institutions will adopt. Awards the need to move away from the current opt-in rule of confidentiality, on the basis of which awards are only published on a piecemeal basis if the parties consent to it, to go toward an opt-out principle, and that is the reform that the ICC has recently adopted, whereby awards would be, as a matter of principle, published with the names of the parties, of the arbitrators, unless one of the parties object. And why should awards be published? First, because allowing parties to understand who is sitting in other cases and outside cases will, of course, better inform appointments made by the parties. Second, because allowing arbitrators to refer to past cases in a more systematic manner will enhance the quality of the awards. We should not forget that in many industries, like construction, for example, there are others, most of the disputes are resolved by arbitration. The fact that awards are not published, the fact that there is only access to them on a piecemeal basis, as opposed to a systematic access to awards, is something that hampers the ability of arbitrators to have access to precedents and therefore to refer in their awards to what other tribunals have done in similar situations. And third, because the systematic publication of awards will allow the formation of an arbitral jurisprudence, kind of a jurisprudence constante, and will allow arbitration to contribute to the formation of the rule of law. Again, this is particularly relevant in industries where most, if not all, of the disputes are resolved by arbitration. And finally, because that there are questions that are addressed by soft law rules such as the IBA guidelines on party representation that are of fundamental importance, such as what are the duties of counsel in an international arbitration? Is there a duty of candor? Does counsel have a duty to advise its client to comply with document production orders? Should counsel refrain from submitting or correct false or misleading expert or witness evidence? Should arbitral tribunals have the power to discipline counsel? All these are fundamental questions for the integrity of arbitration, and these questions cannot be left to domestic law. They cannot be left to domestic professional codes, to bar rules, which include inconsistent solutions. There is the need for transnational rules. There is the need for a globally accepted transnational code of level playing field. Again, as I said, the LCIA has to be commended for having introduced such rules. First, the IBA has adopted in 2013 its guidelines for party representation in international arbitration. These guidelines have been adopted by institutions such as the ICC and institutions globally should now develop this and develop rules on counsel conduct. So to conclude, what I was saying is that these three reforms, establishing a global standard, ensuring the full disclosure of conflicts, establishing transparency for institutional decision making, for governance, for the publication of awards, establishing a global standard for advocacy and counsel conduct. These are reforms which would go a long way in establishing the legitimacy of arbitration in the decades to come, and to strengthen arbitration as a global system of justice. And as I said, these reforms cannot, in my view, be made by states, because arbitration is global and because states, of course, will not be able to establish these global standards which are needed. The route of an international treaty is also fraught with difficulties, so that it is the self-regulation of the international arbitration community by institutions which would to implement much needed reforms. Thank you very much.